and assist that community. And give you some insight into some of the legal issues that we've come across while acting for members of that community. So my name's Patrick Dunn. I'm a solicitor in Dentons Insolvency Recovery and Restructuring Team, and I'm the Dentons coordinator of the Trans and Gender Diverse Legal Service, a service which is the first of its kind in Australia and is specifically designed to be accessible and provide legal advice and representation to members of the trans and gender diverse community, and that's run in partnership with the Inner City Legal Centre in King's Cross. And my pronouns are he, his and him.
Hi everyone, my name is Elouise. I'm a solicitor in the Banking and Finance Regulation and Compliance team at Dentons. Like Patrick, I'm also a volunteer with the Transgender Diverse Legal Service, and my pronouns are she, her.
Afternoon everyone and welcome. My name is John Hurd. I'm a barrister at the Victorian Bar. I practice in commercial litigation, insolvency and banking and finance. My pronouns are he, him, and I'm delighted to be here today.
Okay, so just to start us off, I want to deal with a couple of background matters, just so we all understand what we're talking about today. A couple of definitions. The first is sex. What does sex mean? Sex is a biological question, and it's about an individual's reproductive organs. Now, at birth, most of us, based on the reproductive organs we're born with, are assigned as either male or female. And then another category is intersex, which you'll hear a couple of times today. And intersex describes individuals who don't fit in to the two binary categories of male and female. It can be for a variety of reasons. It can be because they're born with reproductive organs that have sexual characteristics of either the male or female sexes, or they don't have fully developed reproductive organs of either sex. Ultimately, it's really a medical question. But intersex is limited to an individual's sex as determined by reference to their reproductive organs. And we have trans or transgender. And an individual who is trans or transgender is an individual whose gender identity does not match the sex with which they're assigned at birth. They can be a trans man, for example, which is somebody who is either intersex or assigned female at birth and chooses to live as a man. Alternatively, and vice versa, a trans woman is someone who can be intersex or assigned male at birth who chooses to live as a woman. And then you have other categories such as gender diverse or gender queer or non-binary, where individuals who identify as those with those sort of words don't necessarily identify with the gender dichotomy and identify somewhere else on the spectrum of gender. So today we're going to cover a few topics which we think are really important and relevant to Australian businesses. First, Elouise is going to have a talk to us about how individuals can change their ID documents to have their sex marker on their ID documents match their gender identity. And for businesses, it's really important because ID documents are needed for a whole range of things, from employment to the provision of goods and services. And it's important for businesses, therefore, to understand the challenges that trans people face with changing their ID docs. Elouise and I are both going to have a talk to you about anti-discrimination law, the importance of which businesses should be self-evident. You can't discriminate unlawfully, and if businesses do discriminate unlawfully, then they're liable to have complaints made against them. And then finally, John's going to basically give us a narrative of how trans or gender diverse children have been able to get access to gender affirmation surgery through the courts as a demonstration of how treatment of trans issues by the Australian legal system has changed over time. Now, you can see down the bottom of your screen, there's a Q&A button. If you'd like to ask any questions, please put them in there, and if we have time, we can address them at the end of the seminar. So firstly, Elouise is going to have a chat to us about ID documents. Thanks, El.
Yes, so it's really important for trans and gender diverse people to update their official identity documents if their sex or gender identity has changed, or if they've changed their name. So today I'll just give a high-level overview of what the processes are for updating your birth certificate and for updating your passport as well. Next slide, please. So when it comes to changing your name on your birth certificate, the Registry of Births, Deaths and Marriages of each state records official name changes in that state. So generally you'll be eligible to have your name changed on your birth certificate if your birth is registered in the state in which you are applying to have your name changed. Or alternatively, if you were born overseas, you may be able to apply if you have been residing in that state for a certain period of time. So for example, in New South Wales, the requirements are that you've been living in New South Wales for 3 consecutive years immediately prior to your application. If you're under the age of 18 years old, both your parents must make an application on your behalf to change your name. And the only circumstances in which one parent can make an application is if they're the only parent named on the birth certificate, if the other parent is deceased, or if a court has specifically approved the name for the child. You may change your name once in a 12-month period, and some states a total of 3 times only. And that's important for trans and gender diverse people to be aware of if they're trialing a new name. With your application, you'll return your original birth certificate, and then you'll be issued a new birth certificate with your new name, but also listing your previous name. Alternatively, you can be issued a change of name certificate. Next slide, please. So for trans and gender diverse people to actually change their sex on their birth certificate, the requirements really vary from state to state. Like with changing your name, you'll apply to the Registry of Births, Deaths and Marriages in the state in which you were either born or you've been residing for a certain period of time. So the requirements in New South Wales and Queensland for having your sex change on your birth certificate are amongst the most strict. And that's because the main requirement is that you've undergone a sex affirmation procedure or a sexual reassignment surgery. So a sex affirmation procedure or a sexual reassignment surgery is defined as a surgical procedure that involves the alteration of a person's reproductive organs for the purpose of assisting that person to be considered a member of the opposite sex, or for the purpose of correcting or eliminating ambiguities relating to the sex of that person. So the emphasis of the definition really is on the need for a surgical procedure involving the reproductive organs. And so this is quite a high threshold, and as a result, things like top surgery in transgender men doesn't actually qualify as a sexual reassignment surgery. If you do meet these strict requirements, you can apply to have your new sex recorded on your birth certificate as male or female, or in New South Wales as non-specific. And what you have to do is you have to provide statutory declarations from 2 medical practitioners verifying that you've undergone a sex affirmation procedure. The new birth certificate will then not disclose that a sex change has taken place, but if your name has changed as well, it will show your previous name. Next slide, please. So if you were born in Victoria, the process for changing the sex on your birth certificate actually changed as of the 1st of May this year. So previously the requirements were similar to New South Wales and Queensland in that you needed to have undergone a sex affirmation procedure. But the Victorian government enacted reforms last year to enable trans and gender diverse people in Victoria to change their birth certificates without the need for surgery. And this was a really, really important reform. So now, in order to change your sex on your birth certificate in Victoria, you simply provide a statutory declaration that you believe your sex is the one you've nominated in your application, and a supporting statement from an adult who's known you for at least 12 months, stating that they believe the application is made in good faith and that they support the application. Victoria is now perhaps one of the most progressive states because it allows people to actually not self-nominate their sex on their birth certificate as male, female, or any gender diverse or non-binary descriptor of their choice. However, the Registry of Births, Deaths and Marriages can choose to refuse to register a descriptor that is either obscene or offensive or not reasonably established as a sex descriptor. These reforms have brought Victoria in line with Tasmania, Northern Territory, South Australia and the ACT in removing the need for surgery. In WA, next slide please. Stay on this slide. In WA, the system's a little bit different. So in order to register a change of sex in WA, you'll need to be issued a gender recognition certificate by the Gender Reassignment Board. So the Gender Reassignment Board is a government authority that's established by the WA government, which is responsible for determining applicants and applications for recognition certificates. So a gender recognition certificate is the official document that recognises a person who has undergone a reassignment surgery as being of the sex to which they have been reassigned. So in order to be eligible for a recognition certificate, you must be aged 18 years or over, or if you're under 18 years, your parents have to make a statement that they support the application and they believe it's in your best interests. And then the second requirement is you must have undergone a reassignment procedure. So you must have either undergone this reassignment procedure in WA or if it took place outside of WA, to be eligible for a recognition certificate, you need to have been born in WA or living there for at least 12 months at the time of your application. A reassignment procedure is defined as a medical or surgical procedure or a combination of such procedures to alter the genitals or other gender characteristics of a person for the purposes of helping them to identify as a person of the opposite sex. So here we can see that the definition is actually a lot broader than New South Wales and Queensland, because it recognises that the surgery can either be surgical or medical, and the procedure can also alter other gender characteristics, not just the reproductive organs. So this means that hormone therapy alone is sufficient, and something like top surgery in transgender men will also be sufficient. 1 month after you've been issued your recognition certificate, that you can then apply to the Registry of Deaths, Death Marriages in WA to have your new birth certificate issued with your reassigned gender. Next slide, please. So the next document I'll touch on is your passport. So you can apply to the Department of Foreign Affairs and Trade to have a passport issued marked M for male, F for female, or X for indeterminate or intersex. All you have to do is complete a passport application form and provide documents as evidence of your identity, citizenship, and preferred sex. So the documents you can provide to show this are either a copy of a birth certificate showing your correct sex and your changed name as well if you're also applying to change your name on your passport, or you can provide a recognition certificate issued by the Gender Reassignment Board in WA, or a recognised details certificate if you're born overseas. If you were in the process of transitioning to another sex, you must provide a letter from a registered medical practitioner or psychologist certifying that you have had or are receiving appropriate clinical treatment for a transition to a new sex. And if you wish to have your sex recorded as X, you have to provide a statement from your medical practitioner or psychologist certifying that you are of indeterminate sex or you are intersex. So if you're changing your passport on your sex on your passport, to X, there will be some countries that you actually can't travel to because those countries won't recognise that marker, and Smart Traveller can provide a list of these countries. If you wish to change the sex or name on your passport and you've already hold an Australian passport with at least 2 years validity, you may be entitled to a free replacement. So I've just touched on 2 kind of key documents that trans and gender diverse people need to think about updating, but of course there are a number of others, including things like driver's licenses and Medicare and Centrelink records. And also for your business, you need to consider whether your employees who have transitioned or gender diverse might want to update their employee records as well. So for trans and gender diverse people, having their official identity documents correctly showing the sex and the name with which they identify is really, really important, and it's something we frequently advise on at the Trans and Gender Diverse Legal Service. Now I'll hand back to Patrick.
Oh, apologies. Thank you, Victoria. Starting again, I'm going to talk now about anti-discrimination law. And what I think, what we're going to be talking about is how the protections that individuals are entitled to under anti-discrimination law can actually be affected by whether they've been able to obtain updated birth certificates, for example, and how that, in our view, in an arbitrary way, can adversely impact the protection regime for some trans and gender diverse individuals. So relevantly, at a federal level, you have the Sex Discrimination Act, which provides an anti-discrimination regime specifically for sex, sexuality and gender-based discrimination. And because I'm a New South Wales-based solicitor and I'm most familiar with the New South Wales legislation, I'm going to talk primarily about the New South Wales regime, which exists under the Anti-Discrimination Act, which is a general act dealing with all sorts of discrimination, including gender and sex-based discrimination. But I'll also briefly touch on acts from other states. Now, in New South Wales, what I should say first is there is crossover between federal and state acts. They often deal with the same situation. They can deal with it in inconsistent ways. And so the result of that is that sometimes they can be, combined operation can be confusing. But the general principle is that individuals and businesses need to comply with both laws concurrently. And each act provides a different avenue for individuals to make complaints about unlawful discrimination. Under the New South Wales legislation, that agency is the Anti-Discrimination Board. And when a complaint is made to the Anti-Discrimination Board, the process is that the board will investigate the complaint, will contact the respondent and ask for a written response. And if that response doesn't resolve the complaint, it will conduct a conciliation, which is similar to a mediation, that you'll have an independent member of the board bring the two parties together and try to negotiate a resolution. And if the complaint is not resolved at that conciliation, it can be referred to the New South Wales Civil and Administrative Tribunal, which many of you might be aware is essentially an informal dispute resolution tribunal designed to be accessible for unrepresented individuals. It's designed to be efficient and it's designed to be low cost. And there's also only limited jurisdiction for the tribunal to make adverse cost orders against parties. And it's generally a far cheaper and easier forum for resolving disputes than the court system. And then if an individual isn't happy with the decision of a tribunal, there are limited ways to appeal that decision to a court. And those are judicial review avenues as opposed to merits review avenues. Federally, the relevant body to handle complaints is the Australian Human Rights Commission, which has a similar procedure. It will investigate a complaint, request a written response from the respondent and conduct a conciliation. The difference is that if that conciliation at the Commission doesn't resolve things, the next step is to go to the Federal Court or the Federal Circuit Court, which, needless to say, is significantly more expensive than an administrative tribunal, significantly more complex. And we'd always strongly recommend that individuals going that route obtain independent legal advice and representation in those proceedings. So because it's a less accessible route for complaint, it's really only more appropriate for either instances of unlawful discrimination that only fall under the Sex Discrimination Act, not state legislation, or for more egregious or complex instances of unlawful discrimination. And helpfully, the Australian Human Rights Commission's website actually has a confidential conciliation register which maintains a record of previous conciliations and their outcomes, which is a great resource to learn about how certain complaints have been resolved with outcomes such as financial orders, trainings and apologies. But where conduct breaches both acts, an individual can choose whether to go to the board or the commission. And Elouise later is going to talk about discrimination in the context of sport and how to show how conduct can be a breach of one act but not the other. Next slide, please. So in Victoria, you have the Equal Opportunity Act as their relevant legislation, which deals with gender-based discrimination in a similar way. And you also have the Charter of Human Rights and Responsibilities Act, which is sort of like a Bill of Rights at state level, which applies to the conduct of government agencies. Next slide. In Queensland, you have the Anti-Discrimination Act, and you also have a Human Rights Act there, and complaints are made to the Queensland Human Rights Commission, and if they're not resolved there, they go on to QCAT or for work-related complaints to the Queensland Industrial Relations Commission. Next slide. In Western Australia, we have the Equal Opportunity Act, and similarly, if things aren't resolved there, they can go on to the State Administrative Tribunal. And next slide, please. So now I'm going to talk about the elements of an anti-discrimination complaint, and I'm going to deal with them generally as they exist under each of the acts, so as to not overcomplicate things by being too statute focused. So there's four elements to any anti-discrimination claim. Firstly, a complainant needs to show that they come under a protected ground. In other words, they have an attribute which is protected under the anti-discrimination legislation, which in our case today is whether an individual is transgender or gender diverse or is indeed identified or perceived as transgender or gender diverse. The complainant needs to show that the discriminating conduct has occurred in a protected area of public life, and those are employment, education, the provision of goods or services, or the provision of accommodation. They also need to be able to establish either direct or indirect discrimination. Now, direct discrimination is different treatment based on an individual's attribute. For example, if a gym refuses membership to an individual because that individual is transgender, that would be direct discrimination. Indirect discrimination is where a requirement is placed on a group of people, and that requirement has the effect of disproportionately disadvantaging a subgroup within that group. For example, if a gym requires applicants for membership to provide photo ID as part of that membership application, that might disadvantage trans applicants who haven't yet been able to complete their change of name on their documents, or who appear in their photo as different as before they transitioned. Though a requirement imposed on a group won't be discriminatory if it is reasonable, taking into account circumstances such as the nature and extent of the harm suffered by a subgroup, and whether the harm can be overcome or reduced. So, for example, if a gym could establish a good reason for requiring photo ID for membership applications, it would be less likely that that conduct or that requirement would be taken to be unlawful discrimination. So next slide, please. So now I'm going to talk about who the relevant acts actually provide protection to. So under the Sex Discrimination Act at federal level, discrimination is prohibited on the basis of a person's gender identity or a characteristic that is generally held or associated with people who have the same gender identity as the complainant. Now, this is important. If you look at the definition of gender identity, it means the gender-related identity, appearance, or mannerisms, or other gender-related characteristics of a person, with or without regard to the person's designated sex at birth. So it excludes it potentially excludes sex, and it focuses on gender, and it focuses it in quite a holistic way, I would say. Next slide, please. That's in contrast to state legislation. So under the New South Wales Act, the Anti-Discrimination Act prohibits discrimination on the grounds that a person or a relative or associate of that person is transgender. And a transgender person is defined as anyone of one sex who identifies or has identified as a member of the opposite sex, and includes intersex people who choose to live as any chosen sex. So what you'll see is the definition isn't limited to gender. It turns on sex, and it's binary in that a transgender person is someone who lives as either male or female. So on the face of it, it wouldn't necessarily seem to apply to individuals who are gender diverse or gender queer. I don't necessarily identify with one of the binary genders, which we would argue is a pretty clear gap in the legislation. And then on top of that, next slide, please. In the New South Wales legislation, there's also this additional concept of a recognised transgender person. Now, a recognised transgender person in New South Wales is a person who has obtained a new birth certificate which has the sex changed to match the gender with which they identify, or otherwise has an amended birth certificate or interstate recognition certificate from another state. So putting that simply, to be a recognised transgender person for anyone other than people from Victoria or those other states that Elouise mentioned, SA, Tasmania, etc., a recognised transgender person has to have had some sort of medical procedure or some sort of surgical procedure to enable them to obtain a birth certificate where their sex marker matches their gender. Now, if you're recognised as a recognised transgender person, that means, as a matter of law, you're recognised as your reassigned sex. So if you're a female to male transgender person, people must treat you as a man. And if you're a male to female transgender person, people must treat you as a woman. For example, if you are male to female, if you're a trans woman, you have the right to be considered for women-only jobs and to receive women-only services, such as attending a female gym. And you can also not be treated differently from other women because you are transgender. Conversely, a non-recognised transgender person is someone who's, if you are a non-recognised transgender person, there's no requirement that others treat you as your preferred gender. For example, if you're a trans female who hasn't obtained an updated birth certificate, an employer is not required to give you or consider you for a women-only job, though you still must be treated fairly where services are offered and they're not limited to one gender. And this is problematic for a few reasons. Firstly, it offers different levels of protection to individuals based on their sex and not their gender. And frankly, we would say that that's arbitrary because realistically, gender-based discrimination occurs in relation to someone's gender because of their conduct, because of how they live, because of how they present themselves. It's not caused by a person's reproductive organs. I mean, you know, that's in a sense a hidden characteristic, whereas the person's gender is the open characteristic, and so that's what's actually linked to the discriminating conduct. Secondly, there are pretty serious barriers for people often to obtain or get access to gender affirmation treatment. It's the cost. It can be extremely expensive. It's the fact that it's not covered by Medicare, and so for the individual, it's a complete out-of-pocket expense. It's also because it's invasive and it can be subject to complications like any medical procedure, and it can take time. It's not day surgery. And so you're imposing this requirement on people to go out and have this difficult medical procedure in order to be entitled to what I would say should be basic protection under the Anti-Discrimination Act. And on top of the fact that it creates this added burden on trans people generally, it also has different outcomes for trans people based on their lived gender. And look, I'm not a medical professional, but I've been informed that the medical procedures for an individual to transition from female to male are typically more straightforward, I would say, than to transition from male to female. And one of the primary reasons for that is, in order to qualify for having had sexual reassignment surgery, a female to male transgender person can have a hysterectomy, which is unquestionably still an invasive and difficult procedure, but relative to other reassignment surgeries, it's relatively common. It's practiced in all sorts of circumstances. On the other hand, a male to female transgender person needs to essentially have genital reconstruction or genital construction surgery, which to the best of my knowledge is more invasive and more subject to medical complications, and there are higher risks associated with it. And so on top of all the other problems associated with this recognised transgender person provision, you've got unequal outcomes created for trans men and trans women. Going to our other states, I'll also highlight some other, I'd say, problems under this legislation. And I think the problems with these state-based legislation are reflective of the fact that they were perhaps drafted and passed in a time when parliaments had a less sophisticated understanding of trans and gender diverse issues. And so they're not reflective of contemporary understandings. And that means that they perhaps need to be reconsidered and updated to reflect those new understandings. So if I can have the next slide. In Victoria, the definitions are slightly different to the New South Wales legislation. The relevant definition is gender identity, which again, it sort of looks like the federal legislation in that it's about gender, but it's misleading because the term is actually defined as the identification on a bona fide basis of a person of one sex as a member of the other sex. So problematically, again, it's about sex, it's not about gender primarily. And that's whether or not the person is recognised as such. And it's determined by whether the individual assumes characteristics of the other sex by means of medical intervention, style of dressing or otherwise, or by living as a member of the other sex. So again, it's binary. And interestingly, there's also this concept of bona fide basis that isn't present in the New South Wales legislation. But note, you see down the bottom there, it says the identification on a bona fide basis of a person of indeterminate sex as a member of the particular sex. So the extension does extend to intersex individuals. Next slide. In Queensland, the legislation is similar in that the relevant term is gender identity. And gender identity means that a person identifies or has identified as a member of the opposite sex by living or seeking to live as a member of that sex, or is of indeterminate sex and seeks to live as a member of that particular sex. So again, we've got this, this binary definition. And next slide, we go to WA. And I'm sorry for any Western Australians who have logged in here, but I think the Western Australian legislation takes it a step further in terms of the problems I see with it. Our relevant definition there is gender history. A person has a gender history if the person identifies as a member of the opposite sex by living or seeking to live as a member of the opposite sex. So as you can see in that definition, the legislation doesn't extend to offering intersex protection. Not only that, you'll recall that under the New South Wales, Victorian and Queensland Acts, there is at least some protection offered to people based on whether they are transgender, not based on whether they have had gender affirmation surgery. In Western Australia, discrimination is prohibited against a gender reassigned person on gender history grounds. So a person needs to have had some sort of medical intervention, though I will note that you'll recall that Elouise informed you that in WA, the threshold there is lower because you can have hormonal treatment or top surgery, etc. But in my view, at least, it's still problematic that an individual still needs to have that sort of medical surgery and has to stump up for it and go through that process and can't just be offered protection because they choose to live as their affirmed gender. So I think there are various areas in which, next slide please, sorry. So look, what I would say, just summing that section up, is that in my mind, it's clear that there are issues with the legislation, and perhaps because of outdated concepts imported into that legislation, the protection offered by them isn't as broad as it necessarily should be. And so I would encourage you all, in your capacity as employees of businesses or leaders of businesses, to do your utmost to deal with anti-discrimination complaints or discrimination issues in a way that is consistent with contemporary understandings of gender. And that is that you proceed on the basis that people are entitled to discrimination, protection against discrimination on the basis of their gender, regardless of whether they've had some sort of gender reassignment surgery, or regardless of whether they identify with a binary or whether they instead identify somewhere else on the gender spectrum. And I think it's really important in today's environment for businesses to do that and for businesses to keep that in mind. So we're going to talk about a few various areas in where these protections extend to. Employment, education, the provision of goods and services, and the provision of accommodation. And Elouise is going to start us off by talking about employment protections.
Yeah, so I'll just now touch on anti-discrimination protections for trans and gender diverse people and how that intersects with their employment rights at a federal and state level. So there are special protections for trans and gender diverse people against discrimination in the workplace under the Commonwealth Sex Discrimination Act. The wording used in the legislation is that it's unlawful for an employer to discriminate against a person on the grounds of the person's sex, sexual orientation, gender identity, or intersex status. So this means that it's unlawful for an employer to discriminate on the basis that a person is trans, gender diverse, or intersex by imposing certain terms and conditions of employment, by denying them access to promotion or other benefits, or by dismissing them or subjecting them to any detriment or less favourable working conditions. Trans and gender diverse job applicants must be assessed on their merit against the same criteria for the job as other applicants. And in general, trans and gender diverse employees have the same rights to training, promotion, work benefits as other employees, and they must not be dismissed for being transgender or for being in the process of undergoing a transition. At the state level, the New South Wales Anti-Discrimination Act has special protections for transgender people, which prohibits employers from discriminating against a person on transgender grounds. However, in New South Wales, there are no specific protections against discrimination at work on the grounds of gender identity like there is at the Commonwealth level, which means that there aren't any special protections for people who are gender diverse or non-binary or intersex. The anti-discrimination legislation in Victoria and Queensland, on the other hand, does protect people from discrimination in employment and at the workplace on the basis of gender identity. The protections under the WA Equal Opportunity Act are slightly narrower than the Commonwealth and other states. So there are some exceptions to the anti-discrimination laws in the area of employment and work. Under the New South Wales, Queensland and Victorian and Commonwealth laws, it's not considered unlawful to discriminate against a person on the grounds of that person's sex, where being a person of a particular sex is a genuine occupational requirement for the job. So this means, for example, if you are a transgender man and you are a recognised transgender person under New South Wales law, which, as Patrick touched on, means that you must be treated at law as a man, you can be excluded from jobs that require female employees. So for example, if your job requires you to enter female bathrooms and changing rooms, if you're cleaning those areas, you can be lawfully excluded. So above all, the protections for trans and gender diverse people is probably actually the greatest under the Commonwealth scheme, because that legislation specifically prohibits discrimination on the grounds of sex, sexual orientation, gender identity, and intersex status. And so this means that trans and gender diverse individuals who experience discrimination in the workplace on these grounds may want to consider lodging a complaint with the Australian Human Rights Commission rather than going to the relevant state authority. And it's also really important for businesses to think about their HR policies and make sure that they're inclusive of transgender and gender diverse people as well, such as their hiring policies. And that's something that we've definitely made a significant effort to do at Dentons. And I'll now hand over back to Patrick.
Okay, and I'm just going to scoot through the balance of my what I'm going to talk about, because I know that John will be very, very unhappy if I start to cut into his time. So the next protected area is goods and services, and under the anti-discrimination legislation, it is unlawful for a person who provides goods or services, and a person obviously includes a business, or makes facilities available, whether for payment or not. So that's very important. These provisions apply even if your businesses are providing services or goods for free. It's unlawful to discriminate against another person on the ground of their gender identity by refusing to provide the other person with those goods or services, or to make those facilities available in the terms and conditions on which the goods, services or facilities are provided, or in the manner in which the goods, services or facilities are provided. So it's reasonably broad, and it covers the whole spectrum of how a business or an individual can behave via another individual in providing goods and services. Next slide. And then there are further protections in respect of the provision of accommodation. Under the legislation, it is unlawful for a person to discriminate against another person on the ground of their gender identity by refusing that person's application for accommodation in the terms and conditions of the accommodation, by deferring an application for accommodation or giving a lower order of priority to a person who is transgender, by refusing the person's access to any benefit associated with the accommodation, by evicting the person from the accommodation, or by subjecting the person to any other detriment in relation to the accommodation. So again, the provisions there are very broad in terms of how they try to cover the ways in which accommodation can be provided to people. But there are some exceptions to the anti-discrimination provisions in relation to accommodation. And that is that those sections there don't apply where the person who provides the accommodation or their near relative resides at the premises, and the accommodation is for no more than 4 people. So you're talking about share houses, for example, of 4 people or less, where the accommodation is provided by a religious body, or where the accommodation is provided by a charity solely for the persons of one sex or one particular relationship status. So that would cover things such as women's refuges. So just before I hand over to John, there's just one other thing I wanted to say. And I noted earlier that I think it's important that businesses address anti-discrimination complaints in a way that is consistent with contemporary understandings of gender issues, as opposed to the concepts that are perhaps imported into the legislation. And naturally, to do that, business need to actually understand what those issues are. And while we haven't really touched on it today, there are other sort of trainings available. I describe them as trans sensitivity training, where businesses can learn about the trans experience and the various challenges that trans individuals face day to day, and appropriate language, etc. And on our final slide, you'll see our contact details. And if any of you are interested in organising trans-sensitivity training for your businesses, I'd encourage you to reach out to us. And that's something that I'm sure we could facilitate. So sorry, actually, I'm going to pass back to Elouise, who's going to look at sport as a case study for how the various bits of legislation actually operate.
Yeah, so I'll just go through this pretty quickly. So discrimination is not generally allowed in sport, but there are some exceptions when it comes to playing competitive sport, and this can impact trans and gender diverse people. And even though it might not have practical implications for your business, it's useful to see how the anti-discrimination laws can impact trans and gender diverse people in their day-to-day lives, and how the treatment under the Commonwealth scheme can vary greatly to how it's treated at the state level. So under the Commonwealth law, it's not unlawful to exclude persons on the basis of sex, gender identity, or intersex status from participating in a competitive sporting activity if that person is over the age of 12 years and the strength, stamina, or physique of competitors is relevant to the competitive sport. So this is known as the single-sex competition exemption, and the objective is to restrict competitive sporting activity to people who can effectively compete with each other. So the result is that at the Commonwealth level, competitive sports for people over the age of 12 can be limited to a particular sex, but any under 12 sporting competition has to be open to any child of any sex or gender identity. And as you can see from the slide here, the Victorian and Queensland legislation operates similarly to the Commonwealth legislation. Comparatively, in New South Wales, the single-sex sport exemption is a lot broader than the Commonwealth level, and it means that persons of one sex can be excluded from participating in any sporting activity. So there's no requirement for the strength or stamina of competitors to be relevant, or that the person be over the age of 12 years. And so this exemption permits single-sex sporting competitions in New South Wales for children under the age of 12 and children over the age of 12 as well. The New South Wales law actually goes further to say that it's not unlawful to discriminate against a person in a single-sex sporting competition because they are transgender. So this means that a transgender person of any age does not actually have a right at law to play in a single-sex sporting competition as their identified gender, and they can be lawfully excluded from competing as their identified gender. This means we know that this wouldn't apply though if you're a recognised transgender person, because a recognised transgender person at law can be treated as the gender to which they identify. And now I will hand over to John.
Hello again, and thank you, Elouise and Patrick, for that comprehensive overview of the statutory situation, which is evolving. And as we've heard, it is a legal and documentary minefield, and it confronts people who are just trying to live their lives and go about their jobs. So while wider reform projects and campaigns are ongoing, a pro bono casework service like the one run by Dentons and the Inner City Legal Centre is crucial, and Patrick and Elouise and the Dentons team should be commended for that. Now, my job at the end here is to go through some key cases on trans and gender diverse rights. And the richest source of trans and gender diverse case law in Australia is actually family law. And while this was surprising to me at first, on reflection, it does make sense, as changes in society sometimes happen first in the family and in the home. And it's also the case that many of the first and most important decisions that a trans and gender diverse person needs to make involve medical interventions. And because of the things that happen to human bodies as they grow and change, these decisions may also involve parenting and consent issues too. And we know from experience as professionals and as business people that what involves family and kids ultimately also involves businesses, workplaces, and schools, and your customers and staff and clients. It will also impact not-for-profits and sporting and other organisations, as Elouise has just mentioned. And so what happens today in the family court, we know, also ripples out into employment and insolvency and commercial disputes as well. So we will visit the complex and wonderful land of family law. And I've put some cases on that slide there for the people who are interested in looking them up. And I have to say too, it's a bit of it starts off in a pretty weird place, and it's a sad story, but there is a silver lining at the end and some good outcomes. So I should also say that I'm not a family lawyer, but the concepts are not too difficult to understand, or they weren't too difficult for me to understand anyway. If you imagine like I did while I was reviewing these cases, the people and in particular the kids that are behind the case law. So the first place to look is the Family Law Act, the Commonwealth Act, and that's because it defines a child as a person under 18, and that's in Section 4. The Family Law Act also provides that in deciding whether to make a particular parenting order, the family court must regard the best interests of the child as a paramount consideration. And the thing that the Act says will be in the best interest of the child include, and I paraphrase, protecting children from physical and psychological harm, ensuring kids receive adequate and proper parenting to achieve their full potential, and also ensuring that parents fulfill their duties in this and other regards. In family law generally, the parents can consent to medical treatment for their children. However, the family court does have a jurisdiction called its parens patriae jurisdiction, where it gets to decide in relation to what are currently called special medical procedures, which are essentially medical interventions beyond what the case law considers the scope of a parent's power to make decisions for their child. So that actually very patronising matrix is the main way that trans and gender diverse people end up before Australian courts. So let's go through a sad and lonely, but as I said, ultimately good news journey of these three cases. And the first one is Marion's case. And it's only important really as it sets the scene and provides some of the key legal concepts. It has, again, a bit of a weird case history in terms of the procedure, but it ultimately made it all the way to the High Court. And that High Court case, plus the way it was then interpreted when the matter was remitted back down to the Family Court, is the leading case in Australia on the Family Court's jurisdiction to make decisions for a child in relation to special medical procedures. So it's called Marion's case. It doesn't involve transgender or gender diverse people. Instead, it involved an application by the parents of an intellectually disabled 14-year-old girl for an order authorising a sterilisation procedure. In that matter, the court heard that the child was incapable of caring for herself physically, and she was also incapable of properly understanding the nature and implications of the things that would be impacted by the procedure: sexuality, pregnancy, motherhood, etc. And it was also submitted that it was in the best interests of the child that she undergo a hysterectomy and ovurectomy to prevent pregnancy. The application was allowed. And in doing so, the High Court set out these very important criteria for how courts can determine when and how medical procedures can be carried out on minors. And the concern, the High Court said, is to ensure that the procedure is in the best interest of the child. So it obviously picks up that wording from the Act. So the Family Court, when it came back down from the High Court, set out some practical factors for determining whether a procedure was in the best interest of the child. And it's a bit of a shopping list, but it's very important for the cases that follow. So I'll run through it. So the court will hear evidence on the particular condition of the child which requires the procedure. So it's very important in the trans and gender diverse cases and the applications that are made to the Family Court that they set out the medical or the psychological etiology of the issue faced by the child. Previously considered a disorder, but no longer referred to that, gender dysphoria. The next thing is the nature of the proposed procedure, the reasons for the procedure, any alternative courses of treatment available, the desirability and effect of authorising that procedure rather than any available alternatives. And they also consider the physical effects on the child, the nature and degree of any risk to the child of authorising the procedure or not authorising the procedure. And then also, importantly, any views expressed about the proposed procedure and to any alternative proposed procedure by the guardians of the child, including the parents, the custodians, a person who is responsible for the daily care and control of the child, and also the child, as you'd imagine. So these criteria for Marion's case were then picked up in later cases on medical interventions for trans and gender diverse children, starting with a case called Re Alex, which was in a judgment of Chief Justice Nicholson in 2004. We're going to skip ahead a bit from Marion and from re Alex to a case called re Jamie in 2013. And this was a landmark judgment for a lot of trans and gender diverse people in this country. It's sort of a bridging judgment between Marion's case and the current position. Interestingly, and in a way that's fairly standard across these cases, the names of counsel and the solicitors in the matter were suppressed. All of the details of the child and the parents and even their schools and the registry where the documents were filed were anonymised. It was an appeal against orders of a trial judge of the family court in a parenting case. There was no dispute at first instance that the family court's special medical procedures jurisdiction was engaged. And Jamie, which again is not the real name of the child, was 9 at the time of the hearing, which was rapidly brought on because of evidence that malpuberty was advancing in Jamie. Jamie's parents, her doctors, and the children's lawyers assigned to the case all supported or recommended, as was appropriate, Jamie receiving the relevant medical treatment. However, due to Marion's case and that little case, re Alex, where the family court said that Marion's case applies to trans and gender diverse children, they felt they needed to approach the family court for authorization before Jamie could embark on treatment that would align her physical development with her affirmed gender. So they did so. And when it first came before the court found that its special medical's jurisdiction was engaged. There was no dispute about that, and it authorized what it called stage 1 treatment, which involved puberty blocking drugs and which the court characterized as being a reversible intervention. So you've got stage 1 treatment, which involves puberty blocking drugs and which the courts characterized as reversible. The court was also asked if it could authorize stage 2 treatment, which involves more invasive things which at that time were defined as irreversible. And the court said that it couldn't rule on whether Jamie could have stage 2 treatment, as it would be around 6 years before that would need to happen. That was on the medical evidence. And the court said that it couldn't determine at that time what would be in Jamie's best interests so far into the future. So in the result, the position was that the family court was required to make Marion-type orders for medical interventions for trans and gender diverse children. And the case law developed to talk about stage 1 and stage 2 and to think about the changes that were being asked to occur in these bodies, these little bodies. So this set an important precedent, and it was initially seen as a bit of a win as treatment was authorized. So this was 2013, and while it might not seem that long ago in terms of the way society has advanced and its understanding of a whole bunch of things, the fact that the court said that stage 1 treatment could occur in this person who was defined as a child under the Family Law Act was seen as a win. However, Jamie's parents then had a change of heart and they appealed. They didn't change their mind about supporting the treatments. They were still supportive parents of their child. But it soon became clear that a precedent saying that trans and gender diverse kids need the family court stamp of approval for stage 1 and stage 2 treatment was a huge barrier. Now, this is very important. The trans and gender diverse communities have long discussed the onerous and in some cases debilitating medical and legal and other cost barriers they face to simply living their lives. And I think Elouise and Patrick eloquently and elegantly put that earlier. It's a real mess and an injustice. And on an application for Marion-type orders, and some of the estimates I've seen can average as much as $14,000 or so, which includes getting medical reports, counsel to appear, solicitors, filing fees, and lots of that work is done pro bono as well. So the costs are probably much higher. A researcher who is cited in the later cases, Fiona Kelly, put the average costs at between $8,000 and $30,000 per application. I think there is also, it comes out of the literature, a psychological toll to pathologizing and quasi-criminalizing, at least in the eyes of a child, things which are tremendously personal and private, and the details and prospects of an individual's development and sense of self and personhood. So the parents appealed the decision and tried to distinguish stage 1 and stage 2 treatments for trans and gender diverse kids from Marion's case. And because it was on a point of law, the full court of the family court could hear it as an appeal from the orders that were already made. So again, somehow this kid has ended up in Marion land, which was a case dealing with an intellectually disabled person, and where the interests of the parents in that case were recognised to be in some important ways in conflict with the interests and some rights of the child. And that was all absent in Jamie's case. Yet that flavour, the feeling of making decisions for people who cannot make them for themselves and might be vulnerable to the desires of others, infected these cases, and the way the court spoke about trans and gender diverse people and their legal rights. It is, on my view, an unfortunate way to ground the case law. And I understand that it drove many trans and gender diverse people nuts. Very unhappy with this. So not only are you subjected to a psychological diagnosis and all of the stuff that goes on with approaching medical practitioners, in court you are compared to and treated like a person who is very different, and two types of children are conflated when they have totally different capacities and needs. Anyway, the independent children's lawyer in Ree Jamie's case and the public authority, which is not named, did not support the appeal. The Australian Human Rights Commission intervened and supported the appeal for stage 1 treatment, but not stage 2 treatment, and proposed its own test for that. So where did the court end up? In the end, the appeal was partially successful, and it was unanimous. It was 3 judges of the full court of the family court. The court found that stage 1 treatments no longer required court scrutiny. It said that the parents, properly informed, for instance, by doctors and psychiatrists, could make the decision absent any controversy, and effectively that the child could make its own decision about medical treatment. And the main reason that comes out of the judgment is this idea that stage 1 treatments were considered reversible. The court also found, however, that Marion-type orders were still required for stage 2 interventions, the apparently irreversible ones, unless the child was what the court called Gillick competent. And now Gillick is a case from 1986, and it sets out a test for whether or not a child has sufficient understanding and intelligence to enable him or her, or I guess them, to fully understand what is proposed and to give consent. So the court found that it still needed to hear from all of the relevant children and their supporters on this, and an application would still need to be made for a declaration from the court that a child was Gillick competent, or if that declaration could not be made, then the court would still need to make Marion-type orders and would still have a supervisory role for stage 2 treatment. The court in this judgment in 2013 did acknowledge the frustrations and costs involved in this approach, but felt it had no option given that it had to follow Marion's case. So the story continues, and we end up at Ree Calvin, which is a 2017 case. Happily, it ends, this part of the story ends with Ree Calvin. Well, it sort of does, and I'll explain that at the end. Calvin was assigned female at birth. In April 2014, Calvin transitioned socially and identified as a transgender person. Calvin then started using his preferred name at school in 2015. He was diagnosed as having gender dysphoria and had not had stage 1 treatment. However, Calvin wanted to have stage 2 treatment right away, as he was 16 and then 17 at the relevant times. And he was beginning to experience some aspects of female puberty, which was causing significant distress to Calvin. So Calvin's father made an application under the Ree Jamie judgment for a declaration that Calvin was competent to make this kind of decision. And that was partially successful in that the family court found Calvin to be Gillick competent and to consent to stage 2. The court left it there, and so Calvin needed a declaration. And I think there was a strategic decision to stop that declaration needing to happen. The case was actually stated, it's a technical term, up to the full court of the family court. And they asked the full court to confirm Ree Jamie and this idea that you needed a declaration from the court at all to consent to stage 2 treatment. So the court asked itself in a very complex and a bit of a confusing way if Ree Jamie was still good law. And happily for trans and gender diverse people all over the country and their allies and families, the court confirmed that stage 1 treatment does not require court approval. And it went further and decided that stage 2 treatment no longer required any kind of declaration of competence as long as the child consents, the treating medical practitioners agree, and the parents do not object. The court did not need to be involved. The court also in re Calvin introduced the idea of stage 3 treatment, which mainly refers to surgical interventions in the order of chest, reconstructive surgery, phalloplasty, hysterectomy, etc. The judgment, in terms of its tone, focused more on the risks to the child of not providing the requested treatment rather than the risks of providing the treatment and on the benefits of the treatments. And in that sense, it moved to a patient and child-focused analysis instead of speaking from and to the non-trans and gender diverse communities and their preoccupations and concerns. It also benefited greatly from the research and evidence of the Royal Children's Hospital in Melbourne, which is now a world leader in providing care to trans and gender diverse children. And it focused too, and importantly, on the suffering of Kelvin and the trans and gender diverse communities generally. And this sort of analysis was not a key feature of the earlier cases, which did not have the benefit of the latest research and case studies. It also mentioned the risk of trans and gender diverse people obtaining hormonal and other treatments on the internet and referred to medically supervised hormone treatment as an exercise in harm minimization. Now, the judgment in re Calvin was widely seen as a huge win for the trans and gender diverse communities. And if I can have slide 25, please, the next slide. I'll just finish with a quotation from Transcend, which is a support network for the families of transgender children in Australia. And they posted this note after the judgment came down. And I quote, "Transcend is thrilled to advise that the full bench of the family court has overturned the wrong decision in re Jamie. This means no adolescent eligible for stage 2 hormonal treatment for gender dysphoria is required to seek orders or declarations from the Family Court of Australia to access that treatment. It's over, exclamation point. The community can be rightly proud of how we have worked towards this goal over many, many years and finally achieved it, with special thanks to Calvin and his family for bringing it home." And there's another exclamation point. So it's good to end on some good news, and I'll hand back to Patrick.
Okay. I believe we have a couple of questions. So the first one is, a question is, how do we as trans Australians access the legal resources of Dentons for support? And this individual has a discrimination case that's been tied up in NCAT for 2 years, and the individual has been self-represented and arguing against a large team of barristers. In brief, you can contact the Trans and Gender Diverse Legal Service. So you can do that either by calling the ICLC, and you can find their details online, and asking to make an appointment through the Trans and Gender Diverse Legal Service. And those appointments are offered fortnightly on Monday nights. And then you can meet one of our solicitors who's able to sit down with you for about 45 minutes and discuss your case and your legal issues. And if those legal issues are able to be dealt with in that 45-minute session, you can obtain that advice. If they're sufficiently complex that they need a bit more time to be dealt with, advice can be given afterwards. And if we're talking about a request for representation, at that appointment, you can make that request to our solicitor, and then the ICLC and us will consider whether we are able to act on an ongoing basis, and that will depend on the nature of the dispute and the merits and the resources available to the TGDLS at the time. Otherwise, you can also email the TGDLS directly, the Trans and Gender Diverse Legal Service, at tgdls@iclc.org.au. It's tgdls@iclc.org.au. And that will come through to us directly, and we can facilitate an appointment. Another question is, can we get the slides later? Yes, we're more than happy to circulate those to attendees if you'd like to review any of the information. And you'll see on the slide that we have up now, you have our contact details. So please, I'd encourage anyone with any other questions to email us, ask them, and we would be more than happy to respond to you. And the last question is from Jody, a partner at Dentons. Jody has asked, Is the TGD community facing any specific legal issues arising from the COVID crisis? Is the TGDLS seeing any COVID-related issues arising? And I might actually pass over to John to provide an answer to this question.
I've just anecdotally from news and other reports and from friends and contacts on social media, I think there are some issues around access to endocrine tech and hormone treatment, continuity of supply of those things, especially during some of the more panic days at the beginning of the health crisis. There is also a lot of concern around trans and gender diverse people who may have been living their lives in freedom in safe spaces, who have had to return to homes or other accommodation which is not safe. So that's the extent of my understanding of it. I'm not sure if Patrick and Elouise have seen anything specifically coming through the legal service.
So far, we've continued to receive appointments of a general nature like we usually do, and all those appointments have been dealt with over the telephone as opposed to face-to-face for obvious reasons. But as far as I can recall, we haven't had any appointments with trans people seeking advice on issues specifically related to the COVID situation or COVID restrictions. So at the moment, those are all the questions we've received. Thank you to everybody for attending. I hope this has been interesting and informative to you. And has hopefully highlighted, firstly, the challenges that the trans and gender community, the diverse community can face, and why businesses across Australia need to be sensitive to those issues and try to work constructive with either trans or gender diverse employees or clients or individuals they're acting against in an adversarial capacity. And it's just fundamentally important that businesses promote workplaces which are diverse and inclusive for all staff. So thank you, and we'll sign off now. But again, please get in touch if you have any further questions. Thank you.